Are you the target of fake posts, comments, profiles, or harassment on social media and want to put an end to it as soon as possible? By the end of this video, you will learn 4 effective steps you can take to put a stop to harassment, defamation, and other abuse if you are being attacked on social media. Hi, I'm Andrew Stebbins, a managing attorney here at Mink Law, the nation's leading law firm when it comes to dealing with online defamation and harassment. While social media platforms were designed to bring people together, some people use them to smear the reputation of others. When this happens, it is important to act quickly. In this video, I'm going to lay out 4 steps you can take to fight back against social media defamation so that you can confront it head on. You will also learn what social media defamation is and common social media defamation examples. Social media defamation can take many forms. Generally, defamation is an all-encompassing term used to describe a false statement of fact about a third party published to a social media website, platform, or app such as Facebook, Twitter, or Instagram. Social media defamation can be as simple as a negative comment posted on Twitter, or as complex as a coordinated campaign of fake reviews against your business or situations involving the release of personal identifying information, aka doxing. Defamation can be broken down into 2 key types: social media slander and social media libel. While some forms of defamation on social media could be considered slander, such as live streams, the majority of it falls under libel. To prove your defamation case in most jurisdictions, you will need to demonstrate that the statement in question was false and communicated or published about you, communicated to a third party, made with the intent to harm, and has caused you damage. A very common example of social media defamation that we encounter involves sexual assault and other Me Too allegations on Twitter and Instagram. For example, someone at your school starts a sexual assault reporting page where people can write in anonymous accounts of sexual assault. Upon scrolling the page, you discover that someone has falsely accused you of sexually assaulting them at a party 2 years ago. You know that the allegation is false, but the page is popular and everyone sees the post. Before getting a chance to defend yourself, you are branded as an abuser and unable to show your face around campus. For business owners, social media defamation might also involve your business reviews. For example, you might be forced to let an employee go for poor performance. That employee then goes on a shared Facebook group and starts accusing you of committing fraud and withholding pay. The employee also requests others in the group not apply to work for your company and also attacks your company online. Suddenly, and without warning, you get 50 to 100 new 1-star reviews on your Google business page, taking your rating from a sterling 5-star to a poor 2-star, and accusing your business of everything under the sun, including fraud, theft, and racism. People in town see these reviews and stop coming to your restaurant immediately, and people on Facebook even start to call for a boycott of your restaurant. If you are being defamed on social media, doing nothing is not an option. You need to take action and quickly. Every situation is different, but generally we recommend the following steps and advice. Step 1, it can be tempting, but do not respond to your defamer directly. Step 2, preserve the evidence and adjust your privacy settings. Step 3, report, flag, and remove the content. Step 4, consult with an attorney experienced with internet defamation matters. I discuss each of these steps more in the next segments. If you are being defamed on social media, your first reaction may be to retaliate against your attacker. However, in most every case, the best thing to do is not respond. The reason it is important not to respond, especially in the moment, is that emotional, off-the-cuff responses or replies can make matters worse by inviting more comments from your harasser, being used against you in court, and it can open you up to potential civil liability. While an immediate reply might feel good in the moment, it almost always is detrimental to your case. If you want to file a defamation lawsuit over social media libel, you will need evidence. Ensure that you save or copy the defamatory statements by taking screenshots or pictures with your phone. A defamatory statement or post could be removed at any time, either by the author or the platform, so saving a copy is extremely important. Without evidence of the defamation, you do not have a case. If you see a defamatory statement online, you should immediately take a screenshot of the content and copy and paste the URL to preserve it. If possible, it is also important to use a service to preserve the content with the correct URL, time, and date that the content appeared so that the evidence can be admissible in court. While the author might delete the post, the effect of the post can be long-lasting and without some sort of admissible evidence to show the actual defamatory statements, your case will be difficult to win. While you are preserving evidence of the defamatory content and/or profile, you should also consider adjusting the privacy settings on your account or shutting down your account entirely. This can sometimes prevent others from piling on and tagging you in follow-up posts, using your existing data and imagery to add to the harassment, and can potentially mitigate the damage being caused. The next step is to review and report the defamatory content. Most platforms such as Twitter and Facebook provide a way for you to report or flag content that violates their terms of service or standards, such as nudity, violent content, racist remarks, or bullying statements. When you do report offensive or defamatory content to a social media platform, be prepared to explain why it is defamatory or why the content violates the platform's rules. Ultimately, it is up to the online platform to decide to remove the content. Most often, unless it is a clear violation of their terms of service, the platform will not take action. Social media platforms do not want to be the judge and jury deciding what constitutes defamation and what does not. They would prefer to leave that decision up to the courts. If the social media platform determines the content does not violate their community standards or guidelines, or ignores your flag and report request, you may need to work with an internet defamation attorney to pursue legal remedies. Lastly, no matter what the situation, it's important to contact an experienced internet defamation attorney to make sure that you are taking advantage of all your legal rights and remedies and that you're handling the situation appropriately, especially if your efforts to deal with things and have the defamation removed have failed. Working with an experienced attorney, you can pursue legal remedies against the author of the post by sending a demand letter or filing a defamation lawsuit to obtain a court order to remove the defamatory content. If you know who is behind the online harassment, sending the person a demand letter is a great way to get them to stop their defaming behavior and remove the defamatory content that has been posted. A demand letter puts the user on legal notice that you intend to file a lawsuit if they don't stop and follow the demands. This option is often effective and cost-efficient. If the demand letter does not work or just isn't appropriate for your specific situation, then filing a lawsuit to obtain a court order to remove the content and stop the false accusations from continuing may be your next step. Additionally, a legal team that is experienced with social media defamation can help you navigate the social media reporting process and contact social media moderators on your behalf. They can also help you collect and preserve evidence you will need to make your case. By knowing their processes and having points of contact within certain social media platforms, working with an experienced internet defamation attorney can significantly increase your chances of successfully removing social media defamation. One question that many of our clients ask is whether it's possible to hold the social media platform legally liable. Typically, the answer is no. Social media platforms are granted near blanket immunity under the landmark piece of legislation known as Section 230 of the Communications Decency Act, and generally cannot be sued for claims arising out of their users' content. So if you want to file suit for social media defamation, the appropriate legal recourse is to sue the person who wrote the post, not the platform it was published on. With social media becoming so vital to how we interact with one another in the modern era, it makes sense that the attacks on an individual's or business's reputation on social media can have very real and far-reaching effects, such as harm to your personal and professional reputation, loss of business or profits, and psychological damage. Here at Mink Law, we are a single point of contact for everything regarding social media defamation and internet defamation. We have extensive experience removing defamatory content from social media websites, platforms, and apps, and holding individuals who publish this content accountable for their actions. An experienced team of internet defamation lawyers can offer help that may be beyond the capacity of a solo attorney. Complex defamation cases may require a tech-savvy team to help you identify anonymous defamers, implement suppression techniques, and get the content removed, all in one place. Call us for a free consult at 216-373-7706 or head over to minklaw.com and submit a contact form. This is Andrew Stebbins, and I look forward to seeing you in the next video.